heard. We have a right to due process in that part of this whole process. I'm more of the due process at the back end of getting the just compensation if they do get the power of eminent domain. It's an awesome power. It's been described in Pennsylvania as an awesome power. I've described it as maybe the third most awesome power. The first being the power of government to wage war, the second to impose criminal punishment, and the third to take your property from you by eminent domain. It's a great in terms of substantial in size power. It's a dastardly power in the way it's commonly utilized. Yes, sir. Good question, and it ties into the law very much. The question is really, well, is an eminent domain for the public good? How is this good when it's tying into one power plant that's going to benefit from this? And I litigated that issue last year against the same company in a case on a different pipeline. And at that point, the company was asserting the power of eminent domain based on Pennsylvania law. There's a business corporations law in Pennsylvania that provides for the power of eminent domain for a public utility corporation. UGI asserted in that pipeline that they were a public utility corporation. I asserted they weren't because they weren't offering the service to the public. They were offering to a single entity. Here, I think they might be asserting that they're going to offer it to at least one other entity or in some way to the public and avoid that question. I lost in that prior decision last year. It's up on appeal, so I'm not sure what the appellate court is going to do with it. But here, I think that in their at least one public statement I read, that it would be more than just for the one source, that there would be others. And if there is, and that's legitimately to the public, then they would seem to qualify under the Pennsylvania Business Corporations Law. However, I think they're trying to avoid that issue by going through FERC and trying to get the federal approval of this, in which it doesn't implicate the Pennsylvania Public Utility Corporation law. It implicates the federal law in the Natural Gas Act, and FERC, who's a favorable administrative entity, can provide them the power of eminent domain. So I think they wised up a little bit after the fight last year that we had with this same company. It doesn't feel right, it doesn't feel good to me. Good question. Eminent domain is for the public good, and there's a whole series of law as to what defines the public good. And it's good to shut it up at the so yes.
in that easement or right next to it, they told us that they were not allowed to put it in the easement or even close to it because PPL did not allow it.
Yeah, we were told that, we went to us, so.
I mean, how
PPL, the question is with a PPL easement already coming through it, or an easement for electric power line coming through it. Why can't they put the pipeline in that easement or right next to it? And I recognize that PPL has their own property right. They probably have an easement to put their electrical power in, and they can do that, and they can prevent others from interfering with it. So they don't have to allow UGI or anybody else to have any rights within their, say, 50-foot wide or 200-foot wide easement. So they could exclude UGI from doing that, and would probably want to do that. They would not want, in particular, high-tension power lines right next to explosive natural gas. So that makes some sense to me. Potentially, they could run it nearby, have the easements touch up one against each other. And there would be less risk with that than being in the same concurrent easement, but there would still be some more risk with that. But yeah, when you get multiple properties, you're kind of, sometimes you're getting sliced and diced. It's splitting up the property and making it much more, even though you're harmed by the current easement, the new easement, perhaps in a different location, may make eventual further development of that property much, much more difficult. So that might be a big harm because of that case.
My understanding is that landowners can buy some time when take in my opinion. Well, my question is, and also just to answer your question about losing your property rights, or I mean, the devaluing property, I just learned yesterday from another attorney that if your homeowner's company, your insurance company might decide to drop you because they deem you too much of a risk, they're interested in protecting their investment. Similarly, it's even potentially possible that your mortgage holder might decide not to hold your mortgage anymore because they don't want to hold a mortgage with a house that might blow up or that could be contaminated. So there are all kinds of ways that you could lose and your property be valued. At any rate, we have a farm that is right next to the proposed pathway. The pathway. So they won't actually be talking to us, there will be no agreement, we have no negotiation whatsoever. But we have a well, and if there's a leak and it contaminates the aquifer, we will definitely be affected, or if there's an explosion, we will definitely be affected. So what precautions can we take beforehand, and do we have to wait until we're damaged and hurt before we can do anything, or is there something we can do preventively beforehand?
You raise multiple issues. Let me try to address all of them. And the harm to the property can be a great variety of harms. The market takes into account the various harms. At least in theory, the purchaser of the home would recognize the risk that a mortgage might be hard to get or a mortgage might be dropped. Might recognize the risk that you might pay a high insurance rate or have difficulty of obtaining insurance. Well, that should be taken into account in the marketplace, and I think generally it is. So it's not often separated out as a distinct component of damage, but a real estate appraiser expert could take that into account, and part of the information they should take into account. If that impacts market value, the appraiser should take that into account. Your property is perhaps somewhat similar to my property out in Washington County, except they're not filing to condemn your property. So I can't get recovery for your fees and costs. They're coming near your property, and the theory behind this is you can do what you want with your own property. That's part of property rights. I'm an advocate for property rights. Yeah, there can be some constraints under zoning and things like that. But generally, you can do what you want. And that might be offensive to your neighbor, but if you own the property, in general terms, you have the right to do what you want. Same applies for them. They're a neighbor with property rights. They can use that for their purposes. So that happens sometimes. Survey rights. Let's talk some about survey rights. The eminent domain code at section 309 provides for the opportunity for survey rights upon 10 days notice for condemnors. What's a condemnor? Well, a condemnor is an entity that has the power to condemn. Here, UGI has certificates of public convenience and necessity that define them as a public utility that can be a condemnor for those particular projects. They've not obtained the approval status at this point to be a condemnor. They're applying to FERC, the federal government, to obtain that power of eminent domain to become a condemnor, but they haven't obtained that yet. So my argument that would be that they would not, prior to a FERC order, have the right to conduct survey work per the eminent domain code. They might tell you differently. They might come on your land when you're off to work. They might do a variety of different things. But for property rights protection, I think they do not get the survey rights. They will send you a form. They'll request authorization for survey. If you sign the form, you're giving a blank survey permission, unless you restrict it on the form somehow. But if you give blank survey permission, recognize they can use that day or night for different purposes, a cultural study, a wetland survey, a bog turtle analysis. A lot of different studies might go in and a lot of people on your land. However, I usually suggest that's not the time for the fight. Usually a survey really doesn't harm the property. If it does, maybe they dig up a foot worth of soil and it doesn't look the same, but it's not too bad. Usually the survey harm is to be avoided. Condemnors know that the eminent domain code provides for payment of damages if there is harm to the property by survey. So they know that if they damage it, they've got to pay for it. So they try to minimize the harm. So my usual advice to the property owners, it's not the time to fight. Usually it's not going to delay the project here. You know, they're going to get survey rights from a number of different people. They'll tell FERC how many approvals they get, but they'll seek to get the right of eminent domain is what they really want to get, and that's what counts. The survey right, given or withheld, doesn't change the eminent domain status. So my usual advice is to let them do the survey. Sometimes property owner might want to do it on a piecemeal basis. You call me when you want to survey. Tell me when you're going to do it. I'm going to be there. Keep an eye on it. So you can restrict survey access. You can give it on a piecemeal basis instead of a blanket sheet, or you can sign the sheet, up to the property owner. But usually it's not the time to fight for survey rights. It is a use of your property, but it's, the real harm is later on. Yes?
Can you address her question or her statement about insurance companies dropping you and your mortgage company dropping you? Have you encountered that?
I've heard those often. I heard those complaints often. I can't tell you I've seen that happen. I've heard those questions raised. I've heard of the insurance companies wanting documentation. I've been told that either Fannie Mae or Fannie Mac or both of them have provisions in their standard mortgage documentation, which might be buried in 50 pages. But I'm told that those documents, those entities, have provisions to provide them with some opting out of mortgages if there is such a intrusion or harm to the property. One other related thing I want to mention, we're about to wrap up. We've been here for quite a while. But after the process is through, your property might be devalued significantly. You may have an opportunity for reduction of your property taxes as well. After this happens, your property is worth less than it was before. And yet you might be getting taxed at the same rate from your municipality. So you might be able to apply for a tax reduction because your property is worth less. You might have to fight for it, maybe not. Different ones do that very differently, but there's another property right issue that you might be aware of. How about, sir?
We were just recently told that we're a preferred route, and when they came to visit, a couple, 3 times, they expressed that they may be interested in buying the property. Do they actually do that?
That they do on occasion. Most commonly, they're interested in obtaining an easement by purchase or by eminent domain. There are some properties that they might particularly want. They might recognize that this pipeline, by the constraints on the neighbors or whatever, it's got to come right next to the house. And so they're going to have to pay a great deal of money for it. So they might as well try to buy the house. And maybe they'd use that area as a staging area. They need pipes in that area, or they need equipment in their area. So there can be some needs for different areas, construction areas, staging areas, etc., that might push for property right bigger than what you would expect for just a pipeline area. There are also pumping stations that are involved and different things like that come into play. And maybe just 1 or 2 more questions. We're getting late. Yes, sir.
What would you recommend we look for an attorney?
An attorney? I'd look for a fellow down in Hershey. The prominent attorney that does this. I do a statewide practice. I'd love to represent all of you. I'd encourage you, if you're thinking of some local attorney, I'd ask you to compare qualifications. I do more of this than anyone in the state. If you look at my notable cases, you'll see I've had tremendous success in this, and I request the opportunity to represent you and everybody else here. With my assistant, Sarah, and my associate, Tara Horvath, I'd be happy to come and meet with you and protect your property rights.
Yeah, so just to be company, you guys, somebody to operate this pipeline. And what down to people how this company is sufficiently relaxed to cover any possible claims against them in federal action?
UGI itself, and that might be the umbrella company, is a Fortune 400 company.
Yeah.
So tremendous assets there. I can't tell you the details of the specifics here, but I think as part of their FERC application process, they would need to provide proof of the assets being available to cover any of the harms, including the harms to the property damages. When we go to court sometimes for property rights damages, in particular in federal court, we have an obligation for the county of Newark to post a bond adequate to cover the damages. So sometimes we get a bonding requirement there to make sure the money is in place for the property damages. We can sometimes arrange that in state court too. The unusual kind of Newark would have taxing authority, and that provides security for the taking of property. But a private company would have bond authority to provide proof to the court that the assets would be there.
Okay, because my main concern is that this is going to possibly close to a major shopping mall down the line here. If it takes out, it's a multi-million-dollar claim against it.
I would think so. Yeah, I'm familiar with it, and that's what would happen. The project, I think, was it a $170 million project? These are very large companies with a lot of lawyers, a lot of assets, a lot of resources. Even if it were to take out the mall there, I would think there would be coverage of the claims, would be my expectation. I think you have other things more to worry about closer to home. And I'll turn it back over to Jim.
Thank you very much. Just one final word. If you are affected, this is only the beginning of your education. Okay? I didn't, as I said, know anything about this starting in January. I've learned a lot. And like many times I told my students, the more you know, the more you don't know. And this is one of those situations. That's why you do need some expert help in all of this. So, an easement is a permanent thing. It's not something that's going to go away in 10 years. It's basically forever. Know what's happening. What can they do not only now, but what can they do 10 years from now? It's something you didn't ask for. You didn't ask for this complication in your life. But you have to deal with some of you correctly and do the best you can. Thank you all for coming.
One final minute, if I could.
Okay.
There's a question here about hiring an attorney, and I'd like to represent all of you, and I want to explain that a little more fully if I could. The Sarah over at the corner there has a fee agreement document. If you're interested in looking at the document of hiring my services, you can get that from Sarah or give us a call afterwards. But my representation is protecting the property rights, getting the easement language as best we can, and getting the best compensation for it. I do that not on an hourly service basis, but on a contingency fee basis, essentially 1/3 of an increase over their first written offer. So they come and offer $10,000 and I get you $100,000. We've moved them up $90,000, my fee's 1/3 of that, for $30,000, and you're $60,000 ahead of where you were. So that's the basis of my standard representation, and that's how it works, standard in the industry. I'd be honored to have the opportunity to protect your property rights. And I thank you for your very good attention and questions.
There's food back in the corner. Fill your pockets with food. One other announcement on Nicole, give you a date next Friday.
May 29th.
May 29th at Campus Theater in Lewisburg at 7:30 p.m. The movie Merchants of Doubt. I don't think you read the book. Excellent book. I hope the movie's just as good. It gets into the whole issue of on the deniers we're going back to the cigarette industry. I thought getting to the whole diet note of 30 or 40 years from the beginning of the fight to finally get the cigarette